Hello, my name is Christie Arkovich, and we are attorneys in Tampa. We represent student loans, student loan debt relief, foreclosure defense, bankruptcy, things like that. And so I know there's a lot of folks out there right now that are getting payment bills basically from their student loan servicers, and they don't know what to do because when contacting your servicer, a lot of times there's long holds. The times that we've heard are 1 hour, 2 hours, 4 hours even. And I wanted to let you know what happens if you can't or don't make a payment. Essentially, there's something called an on-ramp procedure that the department has put into effect from August of this year, 2023, until August of 2024, that basically states that anyone who can't or doesn't make a payment would be entitled to this automatic protection of the on-ramp program. And so what that means is that the department would not refer the loans to debt collection. They also wouldn't ding someone's credit reports. Now, unfortunately, the Department of Ed does or has said that they can't control what the credit bureaus do. So there's a possibility that there could be some dings still. And so to be absolutely safe, if that is a huge deal for you, it's best to contact your servicer and ask for an administrative forbearance. And then you definitely will not have any dings. But the Department of Ed has said there wouldn't be any dings, even though they couldn't control the credit bureaus. And that, again, is called the on-ramp procedure. That's automatic. You don't have to apply for it or do anything to do that. And so for those long hold times, that might be good for you for that. The thing is that administrative forbearance, I did want to mention, what is that good for? Well, essentially, it means that you would not be making a payment, but interest will still accrue. And that's because the pause has ended. So it's not good for those who ultimately want to pay off your loans because the balance is getting bigger during that process that you're not making payments. But it does count for public service loan forgiveness. So if you're working full-time for a non-qualifying, or for, I'm sorry, a nonprofit that qualifies for public service or a state, local, or federal government, you would be entitled to accrue public service time forgiveness during those months that you're on this administrative forbearance. Generally, forbearances don't count. Now, there is the IDR waiver, which is recounting things going backwards, but that's a one-time special event. And that, remember, expires December 31. So if you have those older FFEL loans, if you've had a number of forbearances, you want to look into that because that's a program that can greatly benefit those with older loans. The IDR waiver, basically it counts, the forbearance, the administrative forbearance counts for the IDR waiver purposes. That is because the IDR waiver is recounting any forbearances, and as long as they meet the definition of an extended forbearance, they will be counted towards forgiveness. So it counts for public service, it counts for IDR waiver. It does not count for your regular IDR payments. So let's say the IDR waiver has occurred, maybe this fall, you've already had it later on this fall or early next spring. If you utilize the administrative forbearance, it will not count, that time will not count towards your IDR requirements if you have a few months left to finish out on a plan, even after the recount has occurred. So this is just a quick overview of administrative forbearance. If you need additional help or questions, you can always reach out to our office. We do strategy sessions, roughly an hour in time, conference call or by Zoom. You can reach us by 813-258-2808. You can also email us at info@ChristieArkovich, and I hope this has been helpful. Have a great day. Bye-bye.